The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Good morning, counsel. Mr. Becker, you may proceed.
Thank you, Your Honor. As I said, my name is Mike Becker on behalf of the appellants. The district court found, and Red River argues here, that Section 702 of SMACRA, the Surface Mining Control and Reclamation Act, provides a legal bar to this action because allowing it to proceed would alter the text of would alter the function of the Clean Water Act permit shield. The text of the permit shield and of the Section 702 of SMACRA, however, do not permit such a result. In fact, it would do damage to the text of the permit shield section and the substantive provisions of SMACRA to interpret it that way. Moreover, a narrow interpretation of Section 702 is necessitated by long-standing principles of statutory interpretation. First, its two statutes should be interpreted harmoniously if at all possible. And second, that a savings clause should not be read to damage the substantive provisions of a statute. I'd like to first turn to the statutory text. SMACRA savings clause provides, nothing in this chapter shall be construed as superseding, amending, modifying, or repealing the Clean Water Act, among other statutes. In order for the savings clause to take effect, there must be something to be superseded, amended, modified, or repealed. Here, what Red River and the court below pointed to was the Clean Water Act permit shield. That section provides, compliance with a permit issued pursuant to this section shall be deemed compliance for purposes of Section 1319 and 1365 of this title, with Sections 1311, 1312, 1316, 1317, and 1343 of this title. There are two important provisions of that text that, when read either together or separately, prevent a textual interpretation that supports Red River's argument. First, the phrase, for purposes of Sections 1319 and 1365 in the Clean Water Act permit shield, must be given effect. Section 1319 is the Clean Water Act's general enforcement section, and Section 1365 is the citizen suit enforcement section. The statement or the phrase, for purposes of Sections 1319 and 1365, can only be read to limit the effect of the permit shield to Clean Water Act enforcement actions. There is no mention of any other statutory or enforcement provisions, and certainly not the citizen suit sections of SMACRA, 30 U.S.C. Section 1270, under which this case is brought. Moreover, there's a specific list of enumerated sections for which limited immunity under the permit shield is granted. If there is tension between the Clean Water Act and SMACRA in this case, it comes from the operation of Section 1313. Plaintiffs are enforcing water quality standards, which are derived from Section 1313 under the Clean Water Act. However, Section 1313 is not listed in this enumerated list of provisions of the Clean Water Act for which limited immunity is given. What Red River's interpretation would do would turn this permit shield into a broad grant of immunity for all environmental enforcement actions, and the text does not support that interpretation.
Counsel?
Yes, Your Honor.
You say that could a citizen bring a suit in this scenario under the Clean Water Act to enforce 1313's provisions? So put SMACRA aside. Could a citizen bring a Clean Water Act case based on your textual understanding of those statutes?
Your Honor, the way the Clean Water Act works is the general provisions of the Clean Water Act are turned into specific limitations in an NPDES permit under 33 U.S.C. 1342. That's the National Pollutant Discharge Elimination System section. And water quality standards can be enforced if they are included in a permit. Then they can be enforced that way. I would point out that SMACRA...
Right, so that wouldn't answer the question, though. What I'm saying is, in this case, given the permit, could a private citizen bring a suit in light of the permits bar under the Clean Water Act?
Only if those water quality standards were specifically referenced in the permit.
And are they, in this case, specifically referenced in the permit? The ones that you're challenging, are they specifically referenced in being violated?
No, Your Honor, I do not believe so, or we would have brought that claim. Our claim under the Clean Water Act below was brought for an unpermitted discharge.
Right. So what I'm trying to get at, and what I'm having trouble understanding of your argument, is that if under the Clean Water Act you could not bring that case, why that doesn't suggest that you should not be able to bring it under SMACRA, given the whatever it is, 702, the numbers escape me, but the savings clause that exists.
Certainly, Your Honor. And I believe, again, it's because of the text of these two statutory provisions. SMACRA savings clause says that it shall not supersede, amend, modify, or repeal the Clean Water Act. There has to be something which is read to be superseded, amended, modified, and repealed. And the only thing that the court below or Red River point to is this permit shield section. But by the text of the permit shield itself, this citizen suit action is outside the scope. Therefore, because we're outside the scope of the permit shield, there's nothing to trigger the savings.
Explain to me one time. I'm not following you at all. Why are you outside the scope of the permit shield? I thought you just said that if you were under the Clean Water Act, you would be inside the scope of the permit shield.
We would be if we were under the Clean Water Act, Your Honor, but this is a citizen suit under SMACRA, or at least the portions of this.
Which can go no broader than the Clean Water Act suit. That's what the permit, that's what the savings clause provides.
The savings clause. The savings clause text does not say it can go no further than the Clean Water Act. It said it should not supersede, amend, modify, or repeal. And again, there has to be a textual provision that interacts with. And that provision here is the permit shield. But the permit shield states that it is for purposes of sections 1319 and 1365. Those are the enforcement sections of the Clean Water Act. The permit shield bars a citizen suit under the Clean Water Act, or a general enforcement suit under the Clean Water Act, if the permit is being complied with. But here, this is outside.
Mr. Becker? Mr. Becker?
Yes, Judge Neiman.
How do you take into account our opinion in Piney Run, where we said that the shield is broader than the permit? All discharges adequately disclosed to the permitting authority are within the scope of the permit's protection. And the hypothetical was, even if the discharges exceeded the permit amounts, the idea was if they were disclosed, they were covered by the shield. And this was Judge King's decision in Piney Run, and he went at it in some length, and it seems to me it's generally being followed.
Yes, Your Honor, we're familiar with the decision in Piney Run. That was an enforcement action under the Clean Water Act. It did.
Well, I'm following up on Judge Richardson's question, because I think it is a very telling question. If we start with the Clean Water Act liability, and the mining company is in compliance, in other words, you could not sue under the Clean Water Act. What they're doing now satisfies that permit. Then you look to not only the statutory engagement you're talking about, but there's that D.C. circuit, which is pretty persuasive, talking about the relationship between SMACRA and I'm talking about the
in-ray surface mining litigation.
Surface mining regulation, yes.
Yes, I would first point out that again, Piney Run was in the context of the Clean Water Act enforcement section. It did not deal with a different environmental statute. What we're dealing with here is a separate statute, section 1270 of...
No, my question's focused just on what Judge Richardson raised. In other words, he started with the notion is, could you have sued for these facts under the Clean Water Act and succeeded? And the suggestion he was raising in his question was that they were in compliance with the permit as construed by Piney Run.
Yes, in Your Honor, my point is I will concede to Judge Richardson's point that we could not bring this under the Clean Water Act and did not bring this under the Clean Water Act. SMACRA provides a separate source of authority for enforcement.
Well, clearly it does, and SMACRA has regulations that go beyond clean water. But SMACRA pretty clearly says, and this was construed by the D.C. Circuit, clearly says it's going to yield to other statutes, so there's not tension. In other words, if you have a permit under the Clean Water Act, the SMACRA wanted the courts to not impose a liability. And matter of fact, in this case, the permit is under SMACRA. It's under Clean Water Act and SMACRA. So you have to answer that question is they are permitted to discharge what they're discharging now under SMACRA.
Your Honor, I think there's 2 points in there. First, this is a jointly issued permit, but as the district court recognized, there are separate sections implementing SMACRA and the Clean Water Act, and those are different sections. In fact, the information, the data that was used by the plaintiffs in the underlying suit came from a portion, the monitoring of the underdrains, which the district court judge recognized was specific to the SMACRA section. As to in-ray surface mining litigation, Your Honor, I would say that in-ray surface mining litigation dealt with the promulgation of statutes. There, the director of OSM was seeking to promulgate statutes that were in direct conflict with statutes that existed under EPA's jurisdiction on the Clean Water Act. The court did not say that those regulations could not be promulgated. What the court says was they had to be consistent. What in-ray surface mining litigation is all about is consistency between SMACRA and the Clean Water Act. Again, what I would say here is that you have to have something to come into conflict, something to be altered or amended or modified to trigger SMACRA's savings clause. And the only thing that has been identified here is the permit shield. Yes, Your Honor.
Can I ask sort of what I hope is a simple question, but just to make sure that I understand, SMACRA governs both point source and non-point source pollution. Is that
Yes,
that's correct? It covers both point and non-point.
That's correct, Your Honor. There's nothing in SMACRA that I'm aware of that makes a distinction, and specifically the performance standards that we are suing under, that we are seeking to enforce, speak of discharges without a distinction between point source and non-point discharges.
And the Clean Water Act is point source.
The Clean Water Act, Section 402, 1342, the NIPDE section, is specific to point sources, but the Clean Water Act does have other sections, such as 1319 of the Act, which do regulate non-point sources. So neither is fairly characterized as specific point sources or non-point sources. Your Honor, I would also just like to point out that doing accepting Red River's interpretation would do damage to both the structure and the text of SMACRA by disallowing the enforcement of performance sections which are part of the Act. I see I'm out of time. Thank you, Your Honor.
Thank you, Mr. Becker.
Good morning, Your Honor. My name is Dabney Carr. I'm here on behalf of the Appalachee Red River Coal Company. I'd like to address the subject that Mr. Becker was addressing in Judge Richardson's question. Just to make sure to be clear here, there was a claim in this case brought under the Clean Water Act, and the holding of the district court was that the permit shield precluded that action, and so summary judgment was awarded on the Clean Water Act claim, and that decision was not appealed. And to a great extent, Mr. Becker's argument is that the permit shield should not apply, but that is a question that was not appealed here. Mr. Becker said that the permit shield holding, that we were outside the scope of the permit shield here. That is an issue which was dealt with in Piney Run. Judge Gregory was on the panel in Piney Run. He will recall that the issue in Piney Run was what was the scope of the permit shield. And the court's analysis was that 1342K was in fact ambiguous. And under Chevron, the court adopted the interpretation of 1342K that was applied by the EPA in a case called Ketchikan from many years ago. And the holding of Piney Run was that the permit shield defines the scope of compliance with the Clean Water Act. So from a quote from the case, that compliance is a broader concept than merely obeying the express restrictions set forth on the face of the MPDES permit. All discharges adequately disclosed to the permitting authority are within the scope of the permit's protection. And so Mr. Becker's arguments about the text of 1342K, that it refers only to sections 1319 and 1365, that it does not refer to section 1313 where the water quality standards are kept, really don't matter, because Piney Run decided that 1342K itself was ambiguous and its scope encompassed everything that was disclosed and within the reasonable compliance of the permitting authority. So those arguments really don't apply here, not to mention which they are essentially attacking the district court's decision on the Clean Water Act claim, which has not been appealed. I also want to point out, to make sure that the court is aware and emphasize, that the discharges from the valley fills at the North Fox Gap mine are not unregulated. Red River has conducted monitoring of the discharges from the valley fills since before this permit was first issued many years ago. And the permit continues to require that we conduct under-drain monitoring and provide that data to DMLR, and we are doing that. And DMLR considered that data when deciding on the effluent limitations and other conditions of the permit. And I also want to point out that, as a district court noted, DMLR's internal guidance requires the agency to assess compliance with both numeric and narrative water quality standards. And it's those narrative water quality standards that are the basis of the SMACRA claim in this case. And during the next permit cycle, when this permit comes up for renewal, which it has, we have applied for a new permit, DMLR will evaluate all this monitoring data and can impose an effluent limitation on these discharges if it believes that that is required. So this is not a case where there is a loophole or a gap in regulation by DMLR. Red River is in compliance with the Clean Water Act by operation of the permit shield. This is a case of regulatory overlap between the Clean Water Act and SMACRA. And SAMS, the appellants, acknowledged that in their opening brief at page 32. And where there is regulatory overlap, Section 702 of SMACRA dictates that SMACRA cannot be construed to modify or supersede the Clean Water Act. And that includes modifying the permit, the scope of the permit shield. All of the circuit courts that have addressed Section 702, and that includes the Fourth Circuit, agree that Congress intended that the Clean Water Act governs where there is regulatory overlap between the two acts. So this case, a case we cited in a footnote in our brief, the Kempthorne case, which was not in directly on point, but the court stated Congress expressly disclaimed any intent to supersede or preempt statutes with overlapping provisions. And in surface mining regulation, which the court referred to, the Congress meant exactly what it said. Where there is overlap of regulation, the Surface Mining Act is not to be interpreted as altering in any fashion the Federal Water Pollution Control Act. And the Sixth Circuit in the ICG hazard case adopted that reasoning from the in-ray surface mining regulation and held that it applied. And I want to talk about ICG hazard for just a moment, because that case presents the same factual scenario that we have here. It was a case where there was a claim under the Clean Water Act for discharges of a pollutant called selenium, which were not expressly included in the permit. It was a general permit, and that was the issue there. And the court held on the Clean Water Act claim that the permit shield applied. And so one of the issues on the appeal was, what was the effect of the application of the permit shield in that case on the SMACRA claim? And the court held that the Sierra Club, which was the plaintiff in that case, that their claims under the Surface Mining Act are effectively barred by operation of the permit shield under the Clean Water Act. So the one issue before this court is whether it should adopt ICG hazard. And so I think an issue for the appellant that hasn't been addressed here is why should this court not adopt the holding in ICG hazard, which is on the same, for purposes of this issue, is on the same facts as here. And the appellant only offers two arguments in their brief for that. The first is that they say that ICG hazard didn't consider the fact that Section 702 is what they call a savings clause, and that the authority from the Supreme Court in two cases called U.S. versus Locke and Geyer versus American Honda apply and do not allow the Section 702 to overcome a substantive provision of SMACRA. The problem with the argument about the savings clause, and it's primarily in the reply brief, is that the appellants treat every statutory provision on which they can put the label savings clause the same. But these statutory provisions vary quite widely. And in particular, the most savings clauses, most things that are called savings clause, are a statutory provision that would save or preserve a claim under the common law or under some state law. And that is the case for all three cases that are cited in the opening brief, those cases being Locke and Geyer and another one called AT&T. All three of those cases dealt with a clause that preserved a state law cause of action. And the issue was, how did that apply when there was some other provision in the act at issue and when they came perhaps in conflict? But cases addressing a statutory provision which preserves state law causes of action aren't relevant to a provision like Section 702, which addresses the interaction of two federal statutes. So Section 702 doesn't just preserve or save a cause of action under the Clean Water Act. It bars SMACRA from being construed to modify or supersede other statutes, that including the Clean Water Act and including other federal law relating to the preservation of water quality. And under the plain language, yes, sir.
Can I ask the same question that I asked your colleague earlier? The permit at issue here, the NPDES or whatever the acronym is a point source permit. Is that fair?
Your Honor, it's a little more complicated than that. It is a.
I thought it was. So explain to me that a little bit. Yeah.
The permit here, DMLR administers both the Clean Water Act program and the SMACRA program. And they issue a joint permit under both programs. And it's when you read the permit, the distinction between what they are regulating under each program is not clear. The district court found in this case that they were regulating these discharges under the SMACRA side of the permit and not under the NPDES or Clean Water Act side of the permit. So it deals with both point sources and non-point sources because it is a joint permit that is issued under both programs, if that answers your question.
Right, but so take the hypothetical, a hypothetical Clean Water Act NPDES permit is a point source permit though.
Yes, in general, but as Mr. Becker pointed out, there are some provisions of the Clean Water Act which regulate non-point source pollution.
And so you could get an NPDES permit for the non-point source provisions of the Clean Water Act, or is the permit itself limited to point source?
No, the permit itself is not limited to point source.
Thank you. That's helpful.
And so our position here is that this is a plain language case, that the plain language of Section 702 applies here, and it would alter or modify the protection of the permit shield if it were to apply to provide that there were no protection here. one argument that was made in the opening brief that SAMS didn't include in its reply brief is that there must be a conflict between the Clean Water Act and SMACRA, and there's no conflict here. But of course, Section 702 doesn't require a conflict. And in addition to that, there is a conflict here between application of the SMACRA claim and the permit shield. I want to make clear that the standards applied for under the two acts are the same. And in fact, that was the case in ICG Hazard as well, where the selenium standards that applied under the Clean Water Act were also the same standards applied by SMACRA. That doesn't matter because the issue is not whether the two statutes apply the same standards, but how they apply them. And here, because of the permit shield, that creates a conflict.
Mr.
And the issue here,
Mr. Tom?
yes, sir.
Would you address what it would to make of the fact that the EPA had objections to Virginia's permit and they were never withdrawn? Does that have an impact in terms of this case?
No, it doesn't, because the objections weren't resolved. So the permit remains in force. And so if the permit is in force.
What's your thought for saying that when the EPA objects and those objections have not been removed, that automatically that means that permit would be enforced?
And then you would, I think technically you would revert back to the prior permit.
All right, so what you're saying, you're operating on the permit that was valid, but not the permit that was last proffered.
Correct.
Right.
Correct. I think.
Well, hold it. Let me ask you something on that question. The EPA, there was a communication gap, and the EPA didn't respond to various provisions, and explanations were provided, but the current permit was issued. And it is enforced just because the EPA took the position that until those things were resolved, it was invalid. Doesn't mean it was invalid, and the plaintiffs have not challenged the validity of the permit.
I think that's absolutely correct, Your Honor. Yes, that you're absolutely correct. And what the 2016 permit, which is the current permit, was the one that the EPA challenged. We responded. It never got resolved, and the district court treated that permit as being the permit in force.
But that's my point. You just seem to concede that you weren't under the current permit, you were under the prior. And my point is that it seems to me no one has challenged or determined invalidity of the current permit. And so for purposes of this litigation, the current permit is what we're looking at, isn't it?
I think that's right. Yes, Your Honor. And if I misspoke, I'm sorry.
I don't see how that could be. As you said, you conceded that you can't be on it because they never withdrew the objection, and therefore that's why I ask you, what authority do you have to say that it's not a matter of whether or not the other side object to it? We have to conclude what the statute's status is. It doesn't change because whether the other side object to it or not. The current permit, you don't have any basis for it. That's why I ask you, what's your authority to say when the EPA makes an objection to the state's permit, and the objections have not been withdrawn, they say that automatically the last one proffered automatically is valid until that's resolved. What's your authority for that? Case law, or otherwise, or regulatory authority?
Yes, Judge Gregory, I'm frankly not prepared to offer you that authority. But I can tell you that that's the law that, and this was an issue that was never.
If that's the law, then you should be able to say what that law is, statutory or regulatory. And that's what I'm suggesting. What happened? Why would the EPA, what changed? They had the objections. The objection is a full stop. You mean to tell me a federal agency makes an objection and then it's not resolved automatically? It means that you can carry on. That's a strange law and application of these things that are very important to our environment. That's what I'm asking you. What's that? And you said that And it makes sense what you said before, that we have to operate on the one that's been valid, but not the one that's still in progress. At best, it's in court, and it has no validity.
We're in a procedurally where it ended up is you're right. EPA objected. It was responded to. Then DMLR went ahead and issued the permit anyway. And so we have an issue where there's either one or two results here. Either the 2016 permit is valid, or because we had applied for the 2016 permit, the earlier permit continues to remain in force even until the next permit issues. So it's one or the other. We did not litigate in this case. Excuse me, Judge Richardson.
Yeah, where does DMLR get the authority to issue the permit? Isn't that provided by the federal regulatory system?
Yes, the authority to issue the permit is delegated to DMLR under the statute. And
so, I guess maybe I just don't understand, but why would, if DMLR has the decision-making authority under the regulatory structure, the EPA or a private citizen could object, but the ultimate authority is DMLR's. So they can just say, we disagree with the EPA and we're going to go ahead and issue the permit. Why is that not a permissible answer for DMLR?
The way the statutory scheme works, that after it's issued, EPA has to approve it.
That's right. That's approval. It's not that the states can just, federalism is strong, but it's not that strong.
Yes, and so in response to your question, Judge Gregory, and I think also in response to your question, Judge Niemeyer, we have this situation where 2016 permit issued and EPA objected. So if it either is in force or if it's not, we are still protected by the earlier permit. And frankly, that was not an issue that the appellant raised at the district court. And it's not an issue that
I understand that it's not an issue in this case, the validity of the permit. Everybody's assumed that there's a permit in place under the Clean Water Act. My question really is, this all occurred when? In 2016, 2015? These exchanges with the EPA?
Right, I think they were roughly 2016.
Yeah, so let's assume 2016. What has occurred in the operation of that permit over the 4 years up till now? I mean, that permit was issued by the state regulatory authority, and everybody's operated under that petition. What has the EPA said since then?
Nothing. We haven't. The information, the letters that be back and forth that were exchanged are all in the record. And
I understand, but after that first exchange where the EPA raised some points and the state authority answered those points in a letter and then issued the permit, my question is, did the EPA then come back and say, we still object, or did they just stop communicating, or what?
Yes. My recollection, and I know it's in the brief, is that the EPA did respond to DMLR's comments and did say we continue to object. And then everyone operated under the 2016 permit. We've done the monitoring and whatever's required. I see my time has expired, Your Honor.
You did so at your peril. The EPA last word was, we've read your response to our objections and we continue to object.
No, sir, I don't think that's at our peril. And that's the point I was trying to make, was that if the EPA doesn't approve it and it's not enforced, though everyone operated that was enforced, and I'm not conceding that it wasn't, but that you would go back to the last permit, that as long as we applied for a new permit, the permit in place, I don't remember the date of it, I think it was probably 3 years before, continues to be in effect until whether or not the new permit will be issued is resolved.
There's a scenario.
So we are protected by one or the other.
No, I mean, that's the fallacy of false dilemma. The third choice is that, no, you don't have any automatic continuation of that permit. That's why you have to seek the EPA's blessings, and you didn't get it. As a matter of fact, they objected to it. So that's why I asked you before, what is your authority for saying that you have this continuation of the last valid permit? You don't.
And Your Honor, I apologize. I can't cite you the code section as we stand here today, but that is the way the regulatory system works. Even right now today, we've applied for a new permit, and we're waiting for DMLR to issue that permit. And the last valid permit continues to apply. And let me just be clear, that is sorry, Judge Richardson.
Can I ask, since this issue wasn't raised below and hadn't been briefed, will you provide us a letter with the authority that you're referring to when court's over?
Sure, that's easy to do. I do want, this was not an issue. This would be a claim of a Clean Water Act violation for a non-permitted discharge. That could have been raised by SAMS below. It was not raised. And they did not appeal the district court's finding on the Clean Water Act claim. Thank you, Your Honor, unless you have any more questions.
Thank you, Mr. Carr. Mr. Becker?
Thank you, Your Honor. A couple points I would like to make in response. First, on the Piney Run issue, Piney Run was clear. It states on page 269 of that opinion that an NPDES permit holder is shielded from Clean Water Act liability for discharges in compliance with its permit. The liability that is
but read the next sentence. Read the next sentence.
And is liable
as
for
EPA is determined, however, compliance is a broader concept than merely obeying the express restrictions set forth in the face of the NPDES permit. All discharges adequately disclosed
are within the scope of that permit's protection. But this is all within the context of Clean Water Act liability. In order to turn the permit shield into something that would comport with Red River's interpretation, you would have to read the sections for purposes of sections 319 and 1319 and 1365 broader than the text would support. You would have to somehow read that section as including section 1270 of SMACRA. I will agree with Mr. Carr that the Clean Water Act claims here are gone. We were ruled against by the district court. Those claims actually were for an unpermitted discharge because we felt that the permit did not cover, the NPDES permit did not cover those discharges. But we did not appeal that because when the district court found that they should in fact have been covered, that they were point sources that should have been included in the NPDES permit, we accepted that the permit shield applied to bar Clean Water Act liability. What we did not accept was that the permit shield would extend so far as to bar compliance under all environmental or to bar citizen suit enforcement under all environmental statutes, including our enforcement action under SMACRA. Yes, Your Honor.
Just so that I'm clear, you have not claimed in the district court or in this court that there is no permit, there is no NPDES permit that's effective at all because of the EPA's objections.
We did not make that claim, Your Honor. You are correct.
What we did, Mr. Carr, that to the extent there's a problem with the 2016, that the regulatory system keeps the old permit in place until a final decision is made on an applied for permit?
I would say, Your Honor, as Mr. Carr said, that issue was not briefed. However, that is consistent with my understanding of the Clean Water Act. I would ask if there's a letter that we be allowed to look into that issue and respond.
It's amazing that you want to respond to something that you already conceded to counsel. Why would you concede to something and now you want a 28?
Your Honor, I've not examined. Excuse me. I've not examined that issue for this argument.
Excuse me, I have something to say.
I'm sorry, Your Honor.
Why would you concede to something you don't know the answer to, and then you would say, I want a 28J letter so I can respond to it? That's what my question is. That's just the construct of advocating. Can you explain?
Perhaps my concession was an error, Your Honor, and thank you. If I may correct myself, I would like to examine that issue and respond.
Thank you. Go ahead if you have something else to say.
Yes, Your Honor. I also want to deal with the citation or the reference to the ICG Hazard case. And I would say the ICG Hazard case, also the Apogee case that are pointed to in the appellee's brief, those were cases that did not examine the text of the permit shield. Each court to look at this question so far has found that there is some tension between the savings clause or some operation of the savings clause through the Clean Water Act permit shield. However, none of those courts have actually examined the text of the permit shield itself. And when you look at that text, I would say that two textual changes would have to be made to find our case within the scope of the shield. First, as I've mentioned repeatedly, the for purposes section, which references 1319 and 1365, would have to be expanded to include section 1270. Additionally, the enumerated list of Clean Water Act provisions for which immunity is given under the Clean Water Act would have to be extended to include section 1313, from which water quality standards are derived. And until you make those two textual changes, you cannot find that this case is within the scope of that permit shield. I would go further and argue that there are other structural elements that support this interpretation. First, the statutory interpretation principle that says you should interpret statutes harmoniously whenever possible. To accept Red River's interpretation of the permit shield would do damage to SMACRA's text. There are three sections of SMACRA at least which would be impaired by the operation of the savings clause and the permit shield as Red River intends. Those are section 1265, which mandate the direct applicability of performance standards to the operator. Section 1270A, that's the citizen suit authority under which this case is brought, which specifically provides that citizens are entitled to enforce any rule or regulation under the statute or issued pursuant to the subchapter, and is not limited to the permit as the corollary Clean Water Act section is. And then lastly, section 1255, which specifically allows for the operation of state law that is more stringent than SMACRA. And one key point that I think has not been mentioned here is the performance standards that we are enforcing here are Virginia SMACRA performance standards. These are the state performance standard. And what 1255 says is those standards under state law are allowed to be more stringent than what's under the federal SMACRA. So in conclusion, Your Honor, I would say that by reading the plain text, by looking at the statutory structure, you find that the only possible interpretation of the interplay between the savings clause and the permit.
Can I ask you something?
Yes, Your Honor.
I'd like to ask a hypothetical. Assume that Virginia properly issued the Clean Water Act permit in this case. And assume also that Virginia has a state regulation that is more stringent. Would the Clean Water Act permit in that circumstance cover the pollution in violation of the state standards?
Both SMACRA and the Clean Water Act allow.
No, under the Clean Water Act. Under the Clean Water Act.
The Clean Water Act as well authorizes state regulations and state limits more strict than the federal limit. So yes, that.
I understand that, but my question is, if the state issues a permit under the Clean Water Act authority it has, does that protect it from any claim that it's violating the state provision?
So if I understand your question correctly, you're asking if there could be a separate state action for limits more stringent than the federal action?
And any kind of action. In other words, if somebody, plaintiff, brought an action in Virginia for discharges from point sources into Virginia waters, and they have a permit for that under the Clean Water Act, does that permit protect them from discharges that might violate the state standard?
Your Honor, and there's a bit of federalism at play here. The state permit is going to be issued under the federal 402 section under that. So it is a state and federal permit. So yes, they would be protected from liability if they were in compliance with that state federal national pollutant discharge elimination system for liability under the Clean Water Act or under the state. The state.
Okay, thank you. That's what I thought, but that's, yeah.
And I see my time is up. If there are no further questions, thank you, Your Honor.
And counsel, so then I'll make sure I'm clear, because I have to understand what your concessions are. You got to be careful when you answer questions. Sometimes they will encircle you. So are you saying that Virginia could not have can Virginia have broader, you agree, broader restrictions than the permit that's done through the regulatory scheme through the federal government? They could have broader restrictions, correct?
They can have more stringent restrictions, yes.
So the answer, to make it clear, you're saying that if point source pollution was regulated strictly under state law, we'll call that sphere A, but sphere B, point source discharge protection, is under the federal one. You're saying that if someone has a permit as to direct discharge on the federal permit in Virginia, even if they violated a discharge under state law only, they would be protected, you're saying?
I believe so, Your Honor, because that permit is issued pursuant to Section 402 of the Federal Clean Water Act.
Right. So the discharge can be broader, obviously a discharge can be broader, I suppose. You're saying it doesn't matter whether it's broad or not. Any kind of discharge in Virginia would be shielded as long as you have a valid permit.
And Your Honor, I would caveat that with pointing out that it would have to be in compliance with all conditions of that permit. So it would have to be in compliance with those more stringent state limitations in the permit to take advantage of that immunity.
Exactly. You still look through the lens, right, in terms of the stringency of Virginia's law would have to be looked through dually through those lenses, right? And that's why it's almost impossible to have a direct discharge without it offending both.
That's correct, Your Honor.
Yeah. Okay. That's all I want to make clarification. All right. Thank you so much, counsel. We can't come down to our normal tradition and shake your hand. Please know that we appreciate your assistance in these very important things, protecting our nation's waters and also protecting the people who carry on companies under permits. And they're not easy, and we really appreciate your helping us with those. I hope that you both will be safe and stay well. Thank you.
Thank you.
Our next case. Proceed.
Good morning. If it please the court, my name is Vic Glassberg. I represent George Wingate. George Wingate's check engine light came on at 2 o'clock in the morning as he was driving south on Jefferson Davis Highway. He pulled over at the first street light he saw, and he stopped. He left his headlights on, his rear lights were on, and he opened his hood. I'll get back to these points because they are elephants in the room that were completely ignored by the district court in its ruling and by defendants in their brief. Officer Fulford was traveling en route Jefferson Davis Highway, and he saw the car. He recognized it as a car in distress. He stopped to help. And as he told Mr. Wingate, this is at page 52 of the appendix, I drive by and I see someone with the hood up. So guess what I'm going to do as a police officer? I'm going to pull over and I'm going to try to help that person. And he also told Mr. Mr. Wingate, and you can hear this. Exhibit 5, that's the video disc at 3 minutes and 5 seconds. It's also at page 110 where it was transcribed. I don't doubt for a minute, man, that you're having car trouble. Nevertheless, the first thing that preoccupied him was getting Wingate's name. And George Wingate was initially detained because he did not give his name. I can't sufficiently exaggerate the importance of the video. Exhibit 5 is 5 minutes worth of clear text and visual information which will inform everything I say. Officer Fulford understood the constitutional standard. In his deposition, this is at page 97, I asked him, is it right that there has to be reasonable suspicion that he committed a crime, that he was committing a crime, or that he was about to commit a crime? Is that correct? Correct. And it was at the point that he refused to give his name that Officer Fulford turned on his mic and requested backup. That's at page 74 and 75 of the appendix. It was because he didn't give his name. Now, when Officer Pinzon came on the scene, Officer Pinzon told him, and this is in the appendix at page 56, and again, you can hear it on the video, you're committing a crime now because you're required to give us your name. In its decision, the district court correctly stated the standard. In the appendix at page 43, the question becomes whether Deputy Fulford had constitutionally sufficient suspicion of criminal activity to warrant an investigatory stop of Mr. Wingate. And that's a proposition that receives de novo review of this court under United States versus Powell. Here was the district court's justification. It's short, and please permit me to read it. Critical to that determination, namely the determination that there was reasonable suspicion, is the time of the encounter, early morning, and the location of Mr. Wingate's vehicle, namely partially on a private used car lot adjacent to used cars of a closed business that had been the victim of criminal activity in the past, and at a time when vehicular-related crime had spiked throughout the county. By the way, the county is 280 square miles, and that's in the record. Without these facts, the court said, without these facts, the court would reach a different conclusion. That was the district court's Terry ruling. But for those facts, there would have been no valid Terry stop as the district court construed it. Now, the deputies added on some additional facts. I will address some of them, but I would like to start by addressing the district court's ruling, which I submit is subject to both legal impeachment and factual impeachment. In terms of the legal standard, I quote from United States versus Black, a decision of this court, 2013. This court has, quote, repeatedly emphasized that to be reasonable under the Fourth Amendment, a search ordinarily must be based on individualized suspicion of wrongdoing. In other words, the suspicious facts must be specific and particular to the individual seized. The points raised by the district court were the following. The time of night, that's not individualized. The fact that there was county-wide vehicular crime, that's not individualized. The fact that this happened in a used car lot, well, anybody who could have been in that lot would have been in the same position. I respectfully submit that the court's reliance on the three factors that it named as essential, without which it could not have found reasonable suspicion, do not permit that determination. Now, I said that there was a factual impeachment as well. And the factual impeachment is the following. While the court said without these facts, the court would reach a different conclusion, based on those facts, Fulford did reach a different conclusion. The conclusion he reached on seeing the car at 2 a.m. in the dark in that lot was, based on his training and experience, that he had encountered a disabled vehicle. That's what he called into to the dispatcher. That's what he told George Wingate, that he came to stop the help. And that is what he told George Wingate at page 110 of the appendix. And again, it's on Exhibit 5, and you can hear it all. I urge you to hear it all. I don't doubt for a minute, man, that you're having car troubles. So
Mr. Glassberg?
Yes, sir.
Mr. Glassberg, when do you contend that Terry stop occurred? At what point in this scenario?
Immediately when Deputy Fulford told Mr. Wingate that he was not free to leave. Now, initially, you'll see it again right at the beginning of the video. He says, "Give me your name." I don't feel any need to give you my name. Well, then he asks, "Am I detained?" First, he said, "No, you're not detained." "Am I free to leave?" "No, you're not free to leave." As of that moment, sir. And that is what the district court found, and I respectfully submit that was a proper finding. And thereafter, Mr. Wingate acted in accordance with that direction. He undertook no effort to leave, until after he was arrested, and then we have that business, but that's not germane to the issues before the court. So my first point is that on the district court's own analysis, that without those facts, the court would reach a different conclusion, is impeached not only legally because he relied on matters of general application and not.
So if I understand your argument, then the challenge is that there was not reasonably articulable grounds for conducting a Terry stop.
Yes, sir.
The arrest was all right, but not the Terry stop. Is that what I understand?
No, sir. The arrest, as Officer Pinzon says, and you can see it in his own statement, Officer Pinzon on page 56 of the brief, "You are committing a crime right now because you're required to give us your name. Please keep in mind, this man was arrested because he didn't give his name. He was not."
I understand.
Yes.
Could he be arrested for not giving his name under the statute?
I don't believe he could, because there's absolutely no basis for concluding that there was a threat to public safety. This was a man who.
So you're challenging both the Terry stop and the arrest, the probable cause for the arrest?
That's correct, sir.
Okay.
That's correct.
Can I ask, just so I understand?
Yes, sir.
It seems like there are two different ideas there. One, you say there's no reasonable suspicion, and I understand that argument. But it seems like you're also saying there was no reason to believe that the public safety required him to give his identification. Would either of those be sufficient, right? So if there was reasonable suspicion of a crime, then you can request identification, right? And so that's a standalone ground. Or if an officer reasonably believed that public safety required identification, maybe it's unconstitutional, but at least the statute authorizes an officer to request the identification. And so either of those would be sufficient.
The statute would be sufficient if it were constitutionally applied. The statute by itself cannot trump the Fourth Amendment's requirement of reasonable suspicion. So if there were reasonable suspicion or circumstances suggesting that there was a threat to public safety, then the two would merge. We have not brought a facial challenge to that statute, although it can be unconstitutionally applied, and here it was.
But what I'm asking is, if an officer, and maybe this isn't an issue here, but I'm just trying to understand how these two fit together. If an officer believed that public safety required identification, say no crime, but no crime, right? So somebody's having a heart attack or there's a medical emergency. And so they say, we need identification because we need to know whether you're allergic to bee stings or whatever it is, right? But public safety legitimately demanded it, but there was no reasonable suspicion of a crime at all. Everybody agrees there was no crime. That reasonable suspicion or a reasonable belief that public safety required identification would be sufficient in this, my bee sting hypothetical.
It would, for the same reason that the Fourth Amendment does not block any number of police intrusions to help people. A police officer doesn't need a warrant to break into a house where there's a fire to save someone or to save somebody medically. But this is a purely criminal matter. This isn't the bee sting. And as I say, we have not challenged the constitutionality of the ordinance. If there's and in fact, we haven't brought the county in as a defendant. I believe that the ordinance was unconstitutionally applied in this case because this was a criminal application with no reasonable suspicion of anything.
And I understand that, or at least it doesn't appear that this argument has been made. But in theory, if an officer at this time of night pulled up behind a car solely to provide assistance, but out of an interest of safety, wanted to provide some name to dispatch in case something bad happened on the side of the road, but there never was a criminal investigation or never a criminal thought in anybody's mind, that in theory, an officer could say at 2 a.m, if I'm going to help somebody with their car, I won't dispatch to know who I'm helping. Could that be a reasonable belief that would justify requesting identification?
Under Heibel, I don't think so, Judge. It's a question of the power of the officer to hold someone. He could have, well, let me step back. Yeah, he could have asked, and maybe he would have answered. But if he doesn't, you can't hold him responsible for doing that without the minimal constitutional requirements that Heibel and any number of cases impose. This is, as we say, a free country, and the police officer simply doesn't have the right to come up to somebody for whatever reason and say, I'd like your name. Maybe you're going to have a heart attack.
Well, but why is that? And then I'll stop. Sorry, I apologize, Chief, for going over. But why is that different from my bee sting example, right? So if an officer pulls up behind a car in the middle of the night solely to provide assistance, it's not on a private lot, there's been no evidence of crime, whatever. The officer has no belief that there's any criminal activity afoot, but for safety purposes says, listen, I just want to give dispatch a name for who I'm helping.
Yeah,
and so, that's a, officer safety concern. And he says, maybe under Heibel, that's unconstitutional, but it's authorized by the ordinance. And then we get to a qualified immunity analysis. But as far as being authorized by the ordinance, that would seem sufficient. Your point about Heibel, as I understand it, is that might be unconstitutional. But that would be a question that we would have to sort of move to the qualified immunity analysis, I assume. Is that a fair analysis?
Yes and no, Judge. When you say officer safety, I have a problem with that. Certainly if you apply it to this case. There are officer safety cases and there are cases that are not officer safety. If Deputy Fulford helped an elderly lady cross the road and asked her for her name, that's fine. There is no officer safety issue in this matter. This is a man who stopped by the side of the road. The deputy doesn't call in, as well he might. Suspicious car, we've had burglaries here, send me back up. He doesn't do that. When you look at the video, don't listen to me or my opposing counsel. Look at the video. These guys are having a chat. You don't see Officer Fulford at the ready. You don't see him blade his body. You don't see him tense. You don't see him looking around. He's chatting with this man. Wingate goes around and closes the hood to his car. He's just standing there. Then they go back and chat. There isn't any issue. Now, of course, you will be told that it's full of potential danger or whatever, but that's all after the fact rationalization. If you look at what he said was, "I'm here to help you. I don't have any doubt that you're having car trouble." He said all those things and acted. His actions speak louder than his words. His actions speak louder than his words. And that, I believe, conclusively demolishes any notion that Fulford was in fear, at risk, or anything. What got Fulford concerned was the fact that he gave an order or request, and police officers are in the habit of being obeyed. I don't fault them on that. That's their job. And sometimes they don't take it very well when they're not. That's what got him riled up. That is what got him to turn on his mic. That's what got him to call for backup. And everything else that has been told and was developed below is after the fact rationalization to justify the stop, which was for an innocuous piece of work. This court has a host of cases within the past 10 years in which this court has said, we keep on reminding the government, you may not criminalize innocuous behavior. You can't just patch together things that people do. The clothing people wear, all sorts of things, and then add them on. But once again, the key here is that the elements that were identified as essential by the district court simply don't support the conclusion. If you have no more questions, I yield my time. Thank you.
Thank you, Mr. Glassberg. Mr. Franco Zenko.
Good morning, Your Honors. Can everybody hear me okay?
Yes.
Okay. May it please the court, my name is Alex Frankozenko, and I represent Deputy Scott Fulford and Lieutenant Dimas Pinzon. Lieutenant Pinzon was a sergeant at the time of the events, and they both were and still are law enforcement officers with the Stafford County Sheriff's Office. Before I get into my prepared argument, I do want to counter one or two things that Mr. Glassberg said. And I think he fell short in describing the district court's opinion. He's correct when he said that some of those objective factors, the time, the location, the level of criminal activity were important factors in the trial court's consideration of reasonable suspicion. But the court doesn't stop there, although Mr. Glassberg did. The court, and this is on page 45 of the joint appendix, and I will continue reading the opinion that Mr. Glassberg, where Mr. Glassberg stopped. And Judge Stringer wrote, and although without these facts, the court would reach a different conclusion, Mr. Wingate also engaged in other conduct that when considered in light of these critical facts pertaining to time, location, further justified the Terry stop, even though the conduct was insufficient by itself. And then Judge Stringer identifies three things that occurred before he was told, Mr. Wingate was told that he could not leave the area. One, immediately exiting the vehicle without any prompting from Deputy Fulford. And there is extensive explanation as to how Deputy Fulford viewed that particular action, that he was distancing, Mr. Wingate was distancing himself from the vehicle, potentially hiding something. Two, wearing all black clothing similar to suspects. identified and apprehended in recent late night larcenies. And 3, explaining his presence regarding the engine trouble while the car the entire time that they were there was running idly and without issue. I agree with Mr. Glassberg. When Deputy Fulford arrived at the scene, he thought
Mr. Frazenko, taking that into account, what criminal activity objectively does that reflect? In other words, the personalized conduct is getting out of the car, wearing a black clothing, and lying about the car, even though he wasn't, as it turned out, but that officer thought he was lying about the engine running. None of that is suggestive of engagement in criminal conduct, is it?
Well, when you take it all, the totality of the circumstances.
Well, the rest of the stuff didn't trouble the officer because when he came to the scene, he thought this was a disabled vehicle and didn't report it, and he didn't act that way. I've looked at the video a couple of times, and it looks to me like he's on the side of the highway. Apparently, where he's parking is also partially on the lot, which abuts the highway. But he's right to the right of the solid white line, and he's under a street light, and he has his hood up. Now, it seems to me if somebody's about to commit some criminal act because of the neighborhood and the time of the night and so forth, I'm not sure how that all fits, and I'm not sure the officer thought that either. The officer thought he was helping somebody. So my question is, I'd like to examine the conduct up until the time when the officer said, "You can't leave." There was an exchange where the plaintiff said, "Have I committed a crime or anything?" The officer said no. And he said, "Then I'm free to go." And the officer says, "Identify yourself." He didn't say yes or no. And the plaintiff then says, "Am I free to go?" And the officer says, "Not right now." "Am I being detained?" "No." "Am I free to go?" "No." So we all agree that's the Terry stop, right?
Well,
and so up until that point, the question is, what is the basis for the officer detaining a citizen without suggestion that there is a crime being committed or has been committed?
In addition, the location of the vehicle, the time of the night,
I understand, but that's not individualized. I mean, every human being going through that location could theoretically be stopped on that basis. So the question is, how do you pick out a disabled vehicle to suggest that the crime's being committed as opposed to anybody else who's there?
Because not everybody would be stopped right there next to the lot. If you're going to commit a crime at a used car lot in the middle of the night, this is a very, and you can see from the video as well, there's nothing else around there, Your Honor. This is it. So
well, Kerry, a reasonable officer comes there. The guy's in a car with his hood up under the light, and he says his engine light came on, and the officer, you think, would think that he's about to steal a car off the lot when he's got his own car parked there. He does not have an accomplice, so he's going to be driving two cars, right? The one he's stealing and his own? Or is he going to leave his own behind and steal another one? I mean, I'm trying to figure out what's in the reasonable officer's mind, and my put together on this is that he came to help the guy, and he was cold, he was casual, but he didn't want to identify himself for whatever reason. But the question is, it was converted into almost an ego battle between the officer and the plaintiff. That's what it looks like.
And Your Honor, what the premise that he was going to steal a car wasn't the basis for some of the suspicion here. What was happening was that catalytic converters parts were being stolen. So when you have a vehicle that's within a couple of feet of these parked used cars, I mean, he could have chose a different location, but he was right next to these cars. It would have taken.
Well, what converted the conclusion reached by the officer that this was a disabled vehicle that needed help to the notion that this is a disabled vehicle ready to commit a crime? What conduct transformed the stop from an assistance to a roadside to a suspicious person? When did that occur in this exchange?
One of the things that Your Honor said that he was under the hood when this happened. That's not. No, I
didn't say that. No, I'm not. He raised the hood. The hood had been up.
The hood was up. Yes, Your Honor.
Yeah. But I have a question. My question is, at what point did the officer reasonably conclude that the situation changed from what I thought was a disabled vehicle sitting on the side of the road, which I had to help, to a situation where I now have a person I suspect of a crime? At what point in the dialogue?
The 3 points, and I agree with the lower courts.
No, this is a finite time. Just tell me. I have the dialogue in front of me. I just want to know at what point in time in the conversation did the officer conclude that I think this is a suspicious criminal, a person with criminal suspicion?
I think when he refuses to give his name, and after he exits the vehicle,
that's totally consistent with disability. If you have been speeding, you usually hunker down and stay in the car and wait for the officer.
Right.
But you're on the side of the road and your engine light's off, or you have a flat tire, and you're sitting in the car or you're standing next to the car, and when the officer comes up, you walk to the officer and say, I got a problem. Now, the officer could have said, what's the problem? He says, my engine light comes on. And the officer could have said, well, I hear it running. And he didn't ask, how's it running? And the engine light's coming on. The next answer would have been what he had in his hand, this cell phone, which reads his computer readout in the car. And apparently he had a one cylinder that wasn't firing right. But the officer didn't know that. He gets the benefit of believing that that was a lie. But that's the most egregious conduct he got up until the time he told him he couldn't leave. It was that the officer, in my judgment, the officer started changing his views about the situation when the guy said, I had engine light problem and the engine was running. But the question is that suspicion of a crime?
Well, that was one of the factors. Again, there was three that were attributable to Mr. Wingate before the suspicion began. Because again, it did not. Deputy Fulford didn't simply arrive there and assume that a crime was committed. No, he got out of his car, and it was his perception that when Mr. Wingate came out of the vehicle, that was odd. It was his perception that when he was dressed all in black clothing, that was a little bit odd at 2 o'clock in the morning.
Now, why didn't he react that way? He didn't react that way. He reacted, how can I help you? What's the problem? You know, this black business, it's pretty chic to wear black on black. I don't know if you ever wear black khakis with a black turtleneck or something like this, but I think that gets you nowhere. I think the best thing you've got is the apparent lie about the engine trouble, because everything looked like an engine trouble problem, yet the engine's running nicely. And so the officer could conclude, and did conclude, he was lying about that. And then he asked him for his ID, but no, he said, yeah, let me have some ID. And then you have this exchange where he says, you're not free to go unless you give me an ID. And the question is, at that point, was the officer suspecting a crime?
Well, I think that when he declined the ID, that was the last factor where there was some suspicion. And again, wearing black isn't a crime. I agree with the court on that point. You know, getting out of your vehicle.
Well, it doesn't have to be a crime going on. You can suspect criminal conduct's being planned, and all the indicators are something's going to happen. you're casing the store, you're walking back and forth. You can. There are circumstantial evidence that can raise suspicion, but the problem in this case that I'm having is the only crime that we have is the ordinance crime, and the ordinance crime doesn't look like that is the basis for the suspicion or the stop. The stop is made basically. He asked for ID. It wasn't. He didn't really rely on that. Maybe your argument has to be he asked for ID and the guy refused to give him ID and then he broke the law. Is that it? Is that the stop?
That's when he technically was susceptible to arrest. Yes, and there is some debate as to when the Terry stop actually began, because even after he was told he wasn't free to leave, he's still.
But if you read the transcript, if I'm reading it correctly, if you read the transcript, I'm not sure that the plaintiff actually said, "I'm not giving it to you." The plaintiff said, have I committed a crime? And then the plaintiff said, am I free to go? And then the plaintiff says, not right now. And then it says, am I being detained? And the officer says, you're not detained. And then a guy says, am I free to go? And the officer says, no. So he had not really, at least in that dialogue, he had not really said, I'm not going to identify myself.
But Your Honor, if somebody's asked multiple times, and I would say if you watch the video, it's probably at least 4 to 5 times to identify yourself or for identification, and you don't give it constructively.
Well, after that, there's a lot of demand for that after that, and he called back up and they asked for identification, for license and everything. That's pretty clear, but that's why I asked when was the detention, the Terry stop, and the question is all we are allowed to consider is what faced the officer up until the time the officer said you're not free to go. Right?
Your Honor, correct. And up until that point, you had the objective factors of nighttime, location, high crime activity, and then you have the perception that the officer had when he exited the vehicle.
Counsel.
And then
Counsel. Counsel.
Yes, Your Honor.
Thank you. I just want to go back to Judge Niemeyer's question to make sure I understood your answer. Judge Niemeyer posits that Mr. Wingate did not refuse to provide an ID. He had not provided it, which you say is constructive denial, but he had not actually refused to provide an ID until after the officer said that he was not free to leave. Is that your, I mean, I think that's the right understanding of the record, but is that correct based on the record as you understand it? Or do you argue that there's a dispute about whether he had actually refused to provide an ID or not?
I'm not aware that was actually a factual dispute in this case. He never provided an ID after being requested several times. I understand,
but I'm asking a very specific question. Had Mr. Wingate expressly stated that he would not provide ID before the officer told him he was not free to go?
No.
No.
He never uttered the word, no, I will not give you the ID. He questioned the officer, why do you need it, or you know, did I do something wrong? Those were his responses every time he was asked for identification. And then when Sergeant Pinzon arrived at the scene, and again, this is before they actually took him into physical custody, Sergeant Pinzon went on and even went further than Deputy Fulford did and explained to him, listen, we've had a string of catalytic converters that have been stolen from these used car lots in this area. He even cites to the ordinance to Mr. Wingate before they go forward with the arrest, and he says, under these circumstances, you know, you're currently violating this particular statute. Again, they didn't arrest him for that statute; they were detaining him. But the whole detention continued to evolve because of the bottom line was Mr. Wingate was evasive. And Your Honor, going back to Judge Niemeyer's points, all these things by themselves, I agree. Getting out of your vehicle, wearing black, none of those things in and of itself create suspicion. But when you throw them in, and this is what the trial court was saying, when you throw them in with the time of night, with the location, and with the high crime area, and then you have, to a certain extent, Mr. Fulford's subjective analysis that Mr. Wingate was being evasive in the way he was answering his questions, and ultimately about the vehicle itself having engine trouble.
Counsel, can I ask you about that? Can I ask you about that question? Because your colleague talked a little bit about the subjective statements on the video where he says, "I don't doubt for a minute that you got car trouble," and you too want to talk about an after the fact subjective belief. How much do those sort of calculate or factor into our analysis here? Either the contemporaneous subjective belief that I don't doubt for a minute, or what you claim is the sort of the after the fact subjective belief that he was allegedly being evasive. Can we give either of those significant weight here?
Well, Your Honor, the I don't doubt for a minute type statement is really his effort to de-escalate the situation. He's saying that to make sure that, you know, Mr. Wingate is calm and that the situation doesn't escalate. He's not going.
What's the record evidence? What's the record evidence for that? Is there testimony that statement was intended to be deceptive and de-escalating?
I don't think deceptive is appropriate description of it, but
there's nothing wrong with it being deceptive, right? If he really believed the crime was being committed, right, but he wanted to lower the temperature, he certainly could be deceptive. There's nothing wrong with it being deceptive there. But what I want to know is not that you believe that might be the case, but is there evidence in the record that that the officer testified later that when I said that, I knew it wasn't true, but I was just trying to de-escalate?
Not attributable to that particular statement, Your Honor, but he did say that he was trying to de-escalate the situation with him, especially prior to Sergeant Pinzon arriving. So the issue of de-escalation, at least on the part of Deputy Fulford, was something that was in his mind when he was dealing with Mr. Wingate. So, and again, I see my time is out. Are there any additional questions, or can I address any other issues that the court may have?
All right, thank you, counsel.
Thank you, Your Honor. Appreciate the time.
Mr. Glassberg, you have some time reserved.
Thank you. The first thing I'd like to do is address a point raised by Judge Niemeyer, who wanted to have as much clarity as possible regarding everything that was said before a determination was made by Fulford that George Wingate was required to give his name. The first thing I'd direct your attention to pages 258 to 261 of the appendix, in which I went through this, but let me read where I summarized all of it. This is at page 97 of the appendix. I would like to review once again, just to lock it in, the factors that went into play at the time you first told him that you required his name. This is page 97. Okay. And that is that it was 2 o'clock in the morning, that he was parked in a used car lot under circumstances where in this period of time, these months, as you have indicated, there were thefts from cars happening, that he was dressed all in black, that he had walked away from the car and towards you, that he said he had engine trouble, but so far as you could hear, his car was running. These were the things that had taken place before you initially told him that he was required to give you his name. Is that correct? Correct. Okay, were there any other factors other than the ones that I've just listed that were in play when you first told him that you wanted his name, or have I listed them all? I believe that's all of them. That is.
Let me ask you this.
Yes, sir.
I read some portions of the excerpt, the transcript that are at page 54, but the question is, do we have the transcript from the very beginning of when it was on?
No.
In other words, I'm trying to find out the fact whether the plaintiff, in this case, Mr. Wingate, whether he refused to give identification at any point before the occasion when I read. Shortly after what I read, he did refuse because they had a discussion. Am I free to go? And he says, you're not free to go. And then he said, unless I've committed a crime, I don't feel like I need to give you identification. And that was as close to his refusal, but that's after he's already been detained. The question is, before that time, is there any evidence in the record of which you're aware where the defendant refused to identify himself? Actually said no.
I can only say that he declined. I don't wish to quibble, but he there is no record evidence of that, and I'm not sure that it happened. It was a it was a casual discussion, or at least as casual as these things can be between a police officer and someone who is getting questioned by a police officer. I am unaware of any flat-out statement, and there was nothing reported to that effect.
Counsel, can I ask, so when I look at JA 227, and this isn't a memory test, right? I'm not trying to get you, but that's a police report that at least might be read to suggest that he refused to give it prior to the detention. Now, it's not a model of clarity, it's a police report, right? But, at least does that create a disputed fact as to whether that had occurred or not?
I don't believe so, because we don't claim that he gave his name. George Wingate declined to give his name. What the issue that was raised by Judge Niemeyer, and that I really don't have a clear answer to because the transcript doesn't exist, is whether he was flat out said, give me your name. No, I won't do that. I can tell you that in the entire portion of which we have a video and audio, that kind of flat out refusal doesn't happen. At a certain point after he's been detained, it does happen, but not before. He was detained for failing to give his name, if I may put it this way, rather than refusing.
Well, it wasn't. If the transcript is correct that I'm reading at page 54, there's a portion of the transcript that you, I guess you're submitting as part of Mr. Wingate's affidavit, and you say this is the transcript. What follows is what was said by me and the officers when I was speaking. And he then puts forth the transcript. In that transcript, he never says he's not going to give his ID. He never declines. What he does is every time the officer says, I need ID, the man asks a counter question. Did I commit a crime? Did I do something wrong? This type of thing. And the officer says, no, no. And then he says, am I free to go? And the officer says, no, until you give me your ID. Well, there's not been up to that point even a declining based on that to give ID. It's just basically he wants to know why you asking me for the ID. And then after a short sentences after, he says, unless I've committed a crime, I don't feel like I need to. Now, at that point, right. He did decline.
Yes.
But that's already after the officer told him he's not free to go. In other words, I think the vulnerable point in this case is whether the Terry stop was legitimate. I think once you get past that and you get to your argument about the arrest, I think you have a tougher time because, at least under the immunity analysis, because the officer was clearly aware of a statute. He may not have applied it correctly, but he was aware of it, and he thought because the man violated the statute, he actually cited it, he could arrest him. Now, whether that's right or not, there may be holes in that. I think that is a tougher question, but I think the Terry stop, the evidence is all there. We have the evidence except the very first few exchanges between the officer and Wingate.
We do, Judge, but what we have in that regard is first what I read to you from page 97, which is the officer's own rendition of everything that happened in one paragraph, and we also have his excuse me.
Yeah, but see, your question was focused on, as was the officer's, was focused on reasonable suspicion about ongoing criminal conduct going on in the neighborhood. In other words, you're trying to find out from the officer why he thought this man was suspicious at that time of night, that time of place, because there's going to be thefts and that type of thing.
Yes,
that's totally different from the legal issue, which seems to me the only one now that the officer has, and that is whether he committed the crime of failing to identify himself, and not the crime of potential theft or this type of thing. And it looks like your question was focused on criminal conduct afoot.
Judge, at that point in the deposition, I expect I may well have been focusing on that, but the statute specifically requires a threat to public safety. And
but the officer, you're going to argue with the officer about whether he thought the public safety was there or not. You can ask him, but he didn't rely on that, and you didn't rely on that, and the court didn't rely on that. Nobody talked about the fact that the public safety was at risk, and I now therefore have to get his ID. What they talked about is suspicion of theft at that time of night.
There's no doubt about that, Judge, because there's absolutely no basis to talk about public safety.
But there's an objective basis. I mean, if we're talking about immunity, there might have been a justification. The officer reasonably believed he could demand ID. And the statute, verbatim, if you go to the statute in its words, you'd have to find some threat to the public safety or in connection and furtherance of the public safety or whatever it is. We would have to look at that on some, you don't look at the subjective basis of what's in the officer's mind. You look at the objective circumstances.
I accept that, Judge, with the only pushback, if I may, that it has to be reasonable. In other words, you can't just come across the situation and say, oh, there's a public safety problem. You can't do that. And I would respectfully submit that the statutory construction merges into the same analysis as applies to the constitutional reasonable suspicion standard.
Okay. All right. Thank you, counsel. Thank you both. And we can't reach you as we would in our normal tradition, but please know that nonetheless we appreciate the arguments and thank you so much for supporting. We should be safe and stay well. Thank you, counsel.
Thank you.
We'll proceed to our final case for you may proceed.
Good morning, Your Honors, and may it please the court. My name is Leslie Griffith, and I represent Plaintiff Appellant National Audubon Society. We're before this court today because the Army Corps of Engineers unlawfully issued a permit to build a terminal groin to artificially harden the shoreline on Ocean Isle. This 1,000-foot-long rock jetty sticking out from the beach would block the natural flow of sand along the shore, dramatically eroding the last undeveloped beach on the island at a cost of millions of dollars of federal and local taxpayer money. But as one federal agency said, this terminal groin would destroy the ecological functioning of the area. At every step in this permitting process, the Corps exaggerated economic costs and minimized environmental harms, favoring the terminal groin. The agency chose to rely on a flawed model and then tried to have it both ways, using and rejecting results depending on whether they favored the terminal groin. The Corps cut short its analysis, looking to just a few years of environmental impacts for a 30-year project. And the agency ignored the overwhelming evidence from expert agencies that the project would destroy the area at the east end of the island. These arbitrary decisions skewed the analysis to favor the terminal groin. Now, the National Environmental Policy Act, or NEPA, demands that the Corps thoroughly study the consequences of a project like the terminal groin and fairly compare it to other alternatives. Thus, so the Corps can make an informed decision, but it's also so the public understands the consequences of those decisions and can weigh in. The Clean Water Act then imposes guardrails on the Corps' decision, requires that they only permit a project if no other project would achieve the same goal at less environmental cost. And underlying both these obligations is the Administrative Procedure Act, making sure that agencies carry out their responsibilities rationally instead of arbitrarily. The Corps failed on all three fronts. I'm happy to answer questions on any of the issues in our brief, but today I want to focus on 3 points. First, the Corps measured environmental harms from erosion one way and economic costs from erosion another way. But the Corps cannot have
you're free to argue that, but the agency gave a fairly rational explanation for why it did that. The economic costs were over a 30-year period. It showed, and you see the drawings, it showed at that corner at the east end, the erosion was actually getting up near the houses, near the road, and they took a 30-year period to compute the economic costs. When it came time to evaluating the environmental harm, they used a period gauged by the refurbishing plans that were done, and they could not project beyond them because of the actual real-life situations. But they gave an assessment as to what was going to happen, and what you're basically doing is trying to compare apples and oranges, and they can't be compared. They have to have different analyses, and that was their explanation. And it seemed they spent some time on giving that explanation, and it seemed quite rational. It seemed to me your standard is to show that what they did in relying on that was irrational, and you suggest it was manipulative, and they basically say that was dictated by the context, circumstances, and the cycling of the refurbishing of the beach under the federal project.
Your Honor, there are two different issues of inconsistency here, and I think you've brought up both of them, and I'm happy to respond to both of them. The first would be the time frame that they measured, and the second is the numbers that they used. And so first on the time frame.
Well, the numbers is a different issue. We can go into that too. I mean, the 408,000 cubic yards as compared to what the last refurbishing was. And there are some explanations for that too, and that may be the most imperfect part of their analysis, I think. But I think your whole argument with respect to a 30-year analysis for the economic impact and the 5-year analysis for the environmental is totally justified by all the data they have, the circumstances in real life. And nobody's mentioned the fact that all the refurbishings, the recent refurbishings, were in a period of time when there were some huge hurricanes hitting that coast. But that's not really, was not relied on. They took an average of 13 years for that sand. But my whole point is, it seems to me if you're going to address and attack the agency to conclude it was capricious, you're going to have to examine what they gave as their reasons for doing it, not that they were, in your point, sort of manipulative and dishonest. They were trying to make a selection between 5 different proposals, and they gave a reason why each one would be good or bad, and they selected the 5th. You have to come now and say that was unreasonable, because we're not scientists. We're basically assessing whether they conducted the necessary investigation and made a rational decision. And so that's your task in proving it. And I'm happy to hear it all, but I can say the comparison between environmental analyses using a different time period than the economic almost doesn't make sense to me the way you argue it. Theirs makes complete sense. I think your argument about the 408,000 cubic yards is a good argument. And the question is that enough to say number 4? I think your choice is number 4, right? Option 4.
Your Honor, there's not, the question here is not sort of what the ideal choice is. The question is the terminal groin permissible? And we are saying that was not the least environmentally damaging alternative that could choose those goals. Or they could achieve.
But they don't have to get they have to they have to weigh all the factors, don't they? They have to look at everything that's happening.
The court does have to look at everything that's happening, and that's something where we think they fell
And so
short.
does the agency, yeah.
Absolutely. And, you know, when it comes to the time frame, I think the explanation given by the agency is irrational, because you can't depend on sort of wiping the slate clean every 2 to 5 years with refurbishment, because in the area that is most vulnerable
They never wiped a slate clean. What they did is they say the data change and for each 5 years, and they have a different a group of data, and therefore they cannot project data in the first 5 years into the second 5 years. They have to conduct a new analysis based on other factors that come in and change it. But they're still looking at the same deal. As I understand it, and I understand your position, is that the beach down at the east end was clearly eroding badly. I've seen some pictures of it. It was getting up to near the streets and the houses. And the idea was to try to get sand and the beach there restored. And the idea was this jetty, this groin, would pile up the sand on the west side of the jetty, but that naturally causes a vacuum on the east side so that the beach erodes more on the east side. But that's only for a fairly short period, and then it turns the corner and the beach remains real wide. And of course, right across the inlet, the whole area is part of the environmental area too, and that's unaffected.
And Your Honor, the area that wouldn't receive beach nourishment under any of these plans is the area that is undeveloped. It's the very east end. And so
it's the east end right near the jetty, not all the way up.
The farthest east end of the island to the east of the proposed groin, right at the inlet, and that area would receive no nourishment. So to measure 3 to 5, to justify looking at 2 to 5 years of environmental impacts based on cycles of nourishment that only happen on the developed areas of the beach doesn't make sense when the relevant environmental impact is to that far end that doesn't receive nourishment. And the other question is what numbers are used, and are you comparing apples to apples or apples to oranges here? And in this case, the impact is really the same set of facts. It's erosion. And what does erosion do to habitat in the area? And what does erosion do in terms of human development, property loss, and requirements for beach nourishment? When you look at the cost of any of these alternatives, it's mainly the millions of dollars of beach nourishment would be required. And so in measuring those, it's important for the Corps to understand for itself, and also to explain to the public and disclose to the public. It's important for the Corps to disclose those numbers on a fair footing within each alternative. And instead, the Corps took the raw model outputs for the purposes of measuring environmental harms from erosion, but rejected those same numbers and used different, much higher numbers, 4 times as high numbers, when it came to measuring the economic costs.
Yeah, but when it measured the 5 alternatives, it did them on a consistent basis. In other words, the environmental assessments for the 5 alternatives were measured similarly and compared similarly. And the 5 years for the economic costs were measured similarly. What was not measured similarly is the economic costs were 30-year assessments, and environmental were 5-year. But they explained that, as I pointed out, and you haven't, in my judgment, pointed out that that was an irrational conclusion. As a matter of fact, it seems to me, from what they said, it's almost the only way you could have done it.
The economic costs and the environmental costs have to be considered in relationship to each other. I think when the public is evaluating these options, they want to know what the shoreline is going to look like, and they want to know that for the purposes of knowing if they're going to be able to walk on the beach or be underwater if they're standing in the same place, what houses are going to be destroyed, if any, versus what the impact to the peaceful undeveloped areas where they recreate are. And if those aren't compared in the same way, it's impossible for the public to evaluate any alternative. In this situation, if you only looked at the environmental impacts section of the environmental impact statement here, you would see pretty minimal erosion estimates no matter what you did. And that includes the baseline alternative, alternative 1, which is maintaining the status quo. And under that situation, you may say that the terminal groin would not drastically erode the east end of the beach, the undeveloped area, but you also wouldn't have any need for the terminal groin because the erosion numbers are so modest and so controllable that, just a modest amount of beach nourishment would account for that. But if you looked then at the economic impact analysis, the cost analysis, and the cost comparison, the numbers used are 4 times as high. And so in that situation, if you're trying to compare alternative 5 to alternative 1, well, alternative 5 then shows dramatic instances of property loss. Or if you're trying to compare to the alternative 3, which is just trying to make up for all the erosion with larger numbers of beach nourishment and additional beach nourishment over and above what's already being done, well, it's immensely expensive. It's tens of millions of dollars more expensive. And so when I, as a member of the public, or as someone in the Corps making decisions, is comparing these, it actually isn't fair between alternatives, because I want to know what am I getting for a certain amount of costs imposed in terms of environmental benefit. If 2 things cost more or less the same amount and one is drastically more harmful, then I'm going to look at it differently than if 2 things cost more or less the same and have incrementally different differences. And here, when we are talking, especially between alternative 4 of channel realignment and alternative 5 of the terminal groin, the cost differences are relatively minor compared to some of the cost differences between the other 2. Those are the ones that are closest in costs. And so the scaling up of economic costs made a huge difference there because the numbers were 4 times as high as those used for the environmental impacts. So to say that it's fine to use one set of numbers as long as you use them consistently across the environmental harms, and another set of numbers as long as you use them consistently across the economic harms, it misses the point that people are looking at an overall bundle of impacts for each alternative. And when those components of that bundle, the economic impacts and the environmental impacts, are not on the same scale and they're on widely different scales, then you're not allowing people to make a fair and rigorous evaluation and comparison of the alternatives. And so it doesn't work for the Corps to make their decision and base their decision on that. And it also doesn't work for the public to be able to understand what's going on here. And I think the idea that the Corps is sort of using the model for only relative purposes and relative comparisons, if that had been what was done, we might be in a different place here. But instead, when it came to economic impacts and economic impacts alone, the Corps decided that some measure of, by their estimate, a more realistic absolute magnitude was important to convey to the public. But they didn't do so for environmental harms. And so we have these drastically different numbers. And so when the numbers that you are showing and the amount of erosion you're showing.
Council, help me understand that a little bit. I mean, abstracting a little bit away from the specifics here, I mean, this comparison often in these types of cases seems very difficult to make, right? You're comparing environmental harms that are often somewhat difficult to quantify with economic harms, which, though difficult, are somewhat easier to quantify, but they're fundamentally sort of look a lot like apples and oranges, and those make for very difficult choices in these NEPA governed cases. How do we understand that? I mean, you're telling us that we ought to treat, and analyze them the same, but intuitively that doesn't make sense. And I understand the Corps' argument to basically line up with that. Help me understand why I ought to think of those 2 things that intuitively feel very different as the same.
Yes, Judge Richardson, I think we have a somewhat unusual situation in the context of this project where we are in fact considering the same impact in 2 different ways. And that's erosion. It's how much sand is lost. And so it isn't a situation where we are looking at one thing in degrees and one thing in inches. It's not, it should be the same comparison. And when you do that, ultimately they're trying to project what the shoreline is going to look like under any alternative. And instead of saying, you know, the shoreline is going to be here, it's going to be this line, and you're going to lose this much sand, and that means beach nourishment will cost X dollars, and you know, this much habitat will be lost. They're using two different shorelines for different purposes. And when you do that, it's not looking at, it's looking at apples and apples and calling one of them oranges. It undermines the transparency that NEPA was designed to promote, and it is the definition of irrational. I see that my time has expired. I'm reserve my remaining time for rebuttal. Thank you.
And your analogy, counsel, you meant you're looking at apples and oranges, but calling them both apples.
Either way, you're not getting a fruit basket that you can compare meaningfully to the other alternatives you're looking at. You have things that is the same. It's erosion under either circumstances, so it has to be compared the same way. So to call
I thought in this case, your position was that the public got a lemon.
That's fair to say. It's a sour deal either way.
I'm not sure the conversation is continuing. We better move on. All right. Thank you. Mr. Grant.
Good morning, and may it please the court. Eric Grant for the U.S. Army Corps of Engineers. I intend to use 16 minutes of Applee's time and give the remainder to counsel for the town of Ocean Isle Beach. I certainly want to jump into the different treatment that was the subject of Ms. Griffith's presentation. But first, I want to start with a couple of things that she said at the beginning, implying that this terminal groin is a disastrous environmental project that ignored the advice of expert agencies. That's just not the case. It's contradicted by the record. On page 1485 of the joint appendix, this terminal groin is described as leaky. It's created with loosely placed armor stone, and that will allow sand and water to flow through the groin and allow the passage of fish larvae and sand. And then Ms. Griffith said that this groin will result in the long-term erosion of sand east of the groin. And that's specifically contradicted by page 1680 of the joint appendix. The Corps' engineering report predicted that for the first year there will be some erosion, but in years 2 and 3 the area will stabilize and there will actually be sand will actually be gained in that area. And then third, in terms of the expert wildlife agencies, I would direct the court to pages 29, 91 and following. That's the Army Corps' actual permit. And it incorporates 6 construction conditions from the National Marine Fisheries Service and no fewer than 22 terms and conditions from the U.S. Fish and Wildlife Service into the special conditions of the permit. And then, of course, the Corps also required at special conditions 34, 35, 53, and 54 required the project to comply with the North Carolina agency's inlet management plan. So the advice of those agencies was in fact not ignored, it was followed. But jumping into the so-called different measurements, one is the different time frame. And as to that, I guess I would start with what this court held in Webster v. USDA, that deciding what details need to be included or omitted from an environmental impact statement is generally a matter left to the agency's discretion. And so consequently, as the district court recognized, NEPA does not impose a requirement that the agency analyze impacts for any particular length of time. That's from page 72 of the joint appendix. The district court was quoting the Selkirk conservation case from the Ninth Circuit. And what's required, as Judge Niemeyer pointed out, is that the Corps explain why it did what it did. And the Corps did that here. And it explained in particular at page 1312 of the joint appendix that accurate future predictions for large-scale and long-term coastal changes are too difficult to make in the absence of necessary capabilities for those predictions. And conversely, on page 1406, that the 3-year model simulation provided sufficient information on which to make engineering judgments. And in fact, the Corps, speaking of apples to apples, on page 145 of the Joint Appendix, an internal Corps email said that it would potentially be misleading to do otherwise because it's hard, quote, to compare apples to apples considering our various alternatives have different nourishment intervals. And so the Corps did give a rational explanation. And going to the difference between the evaluation of economic costs and environmental effects, that too was rational and rationally explained. And in particular, the modeling process, the so-called Delft 3D model, found that the Corps found that accurately reflected erosion trends, but it systematically underestimated the absolute volume of erosion. And so the model required adjustment to more accurately estimate the absolute costs of beach renourishment and property loss. And the Corps forthrightly acknowledged that adjustment on page 1405 of the appendix. So the plaintiff, of course, criticizes the Corps for not making a similar adjustment as to environmental effects, but that decision was rational for 2 reasons. One, the economic cost of erosion is measured in large part in cubic yards of sand that must be replaced, and that's a measure of volume. But the environmental effect of erosion is measured in acres of habitat lost. That's a measure of area. See, for example, the chart on page 1407 of the Joint Appendix, which is reproduced at page 5 of plaintiff's reply brief. Real-world data showed that the model underestimated lost sand volume and needed the adjustment that I mentioned, but no data indicated any problem with the estimate of lost habitat acreage. The second point is that the adjustment for lost habitat acreage, the lack of adjustment for that acreage, made no logical or legal difference. The crucial consideration for the environmental effect of a given alternative is not its absolute size, but its relative size. This is most obvious in the Clean Water Act's requirement that the selected alternative must be the least environmentally damaging practicable alternative. An alternative that is the least environmentally damaging will have that character even if all of the numbers are multiplied by 4, which is what plaintiff seems to want here. Similarly, if the projected difference in harm for each alternative is modest, and plaintiff concedes that on page 5 of its reply brief, then that difference will remain modest if even if all of the numbers are quadrupled. And so looked at both from the perspective of the time horizon and the adjustment for the different types of analyses, the Corps' decision was rational and it explained that to the public sufficiently. And that's all that's required under the...
I want to go back to the, I didn't want to cut you off while you're doing the 2, but can you go back and just help me understand how the volume of sand doesn't translate to acreage? I mean, I'm not a marine expert by any stretch of the imagination, but if you tell me, I get your second point, right? But the first point, if you're removing more sand and we're talking about an island, I'm having a little trouble understanding how a greater volume, 4 times as much sand volume doesn't mean that there wouldn't be a similar reduction in acreage. Help me just put that piece together.
Yes, Your Honor, an excellent question. And as I understand it, it's because the same sand, or sand at the same acreage is being lost over and over again. And so it's a question that the modeling showed the rate at which the sand would be lost didn't match the real world observations. And so the Corps needed to make that adjustment. But in terms of where the sand is being lost, it's the same place over and over again. So the sand could be lost slower or faster, and that would change the volume of sand and the cost of replacing it. But the acreage where the sand was being lost, as I understand the record, did not change. And so that aspect of the Corps' analysis did not need adjustment.
So
and
acreage, so Mr. Grant, acreage doesn't take into account of depth, does it?
No, Your Honor. And
that was the chief way of explaining my answering my question.
And depth is important, because the more sand that has to be dumped, the more damaging potentially to the environment. And that's one of the reasons that the Corps chose alternative 5, the terminal groin, as the least environmentally damaging alternative, because especially in the first 5 years, that alternative required 500,000 cubic yards less sand replacement than plaintiff's preferred alternative, namely alternative 4.
Mr. Grant, do you think it's supported by the record that a groin terminal was absolutely required? Forget about where you placed it and how long it is. Do you think that was, either way you slice it, it would have to be the jetty or the groin terminal to address the problems? Do you think that that's under every scenario?
Well, Your Honor, as we've discussed, the Clean Water Act requires the least environmentally damaging alternative among those that are practicable. And the Corps specifically looked at that beginning on page 2796 of the joint appendix, and went through all 5 alternatives and came up with the bottom line conclusion on page 2805 that the terminal groin alternative is the least environmentally damaging. And I should point out that that conclusion made clear that that alternative must include adaptive management requirements, and particularly those in the so-called inlet management plan. And the Corps made clear that if the groin doesn't work, it will be modified or even removed, and removed at the town's expense. And I would point out, I think it's in condition 54, the Corps made sure that the town provided financial assurance that it could do that if, after doing all the required study and analyzing the data, that the Corps determined that it needed to be modified or removed, it would be done so at the town's expense. I know Judge Niemeyer mentioned the so-called per event beach nourishment cap of 408,000 cubic yards. And I guess I would say about that, it appears to be the kind of fly specking that this court condemned in a case also involving the National Audubon Society, that time against the Department of the Navy, 422 F3rd at 186. Obviously, the volume of sand that can be dredged and dumped on a beach at any one time is not infinite. And so the Army Corps chose per event cap in order to facilitate what it called an equitable comparison among the competing alternatives as to frequency. Again, we're trying to do apples to apples. And the cap was based on the Corps' 3-year budgetary cycle. That's at pages 1312 and 1320 of the joint appendix. And based on, as plaintiff expressly concedes, on historical averages, and that concession's at page 26 of plaintiff's reply brief. And so we submit that that choice was within what the Supreme Court has called the bounds of reasoned decision-making required by the APA. And I guess my second point in regard to the cap is that any error in this regard was harmless. If the Army Corps had rejiggered the cap as plaintiff desired, Alternative 4 would not have required in later years more frequent nourishment than Article 5, than Alternative 5. But Alternative 4 instead would have required 5% larger renourishment than Alternative 5 at each interval. And again, plaintiff expressly concedes this at page 26 of its reply brief. And as I pointed out before, it's undisputed that Alternative 4 would require nearly 500,000 more cubic yards of fill in the first 5 years. And that's at pages 1324 and 1482 of the Joint Appendix. And so the use of that cap, like the other aspects of the Corps' decision, supported the Corps' bottom line conclusion that, quote, Alternative 4 will result in increased environmental impacts and increased cost compared to Alternative 5, unquote. And that's at pages 2802 and 03 of the record. In this case, the town of Ocean Isle Beach and the U.S. Army Corps of Engineers proposed and thoroughly studied alternatives for responding to a very great long-term problem. They chose the least environmentally damaging alternative and reasonably explained that choice. That satisfied the Corps' obligation under both NEPA and the Clean Water Act. The district court's judgment so holding should be affirmed. Thank you, unless the court has any other questions.
Thank you, Mr. Grant. Mr. Ressler.
Good morning, Your Honors. My name is Todd Ressler, and I represent the town of Ocean Isle Beach. The town's beaches at the eastern end of the island have eroded for years. Houses have been lost. The east end of 1st and 2nd Street are gone. 3rd Street is now oceanfront. Despite the town and the Corps' efforts, the beach continues to erode. If Audubon was in charge, it would have done things differently, but that's not the law. Agencies are entitled to select their own methodology as long as the methodology is reasonable. In this case, the Corps' methodology was reasonable. The Corps did not model two different shorelines. It was attempting to answer two very different questions. How much would it cost to implement each alternative over a 30-year period? And what are the environmental indirect effects of each alternative that are bounded by the beach renourishment cycles? Beach renourishment is associated with each alternative. When determining costs over 30 years, these costs must be added up. Each beach renourishment event costs a certain amount, and you add those costs up over time. However, when evaluating indirect effects, each of these indirect effects is bounded by the renourishment cycle. I never thought we would be talking about fruit during this case, but that's exactly what the Corps was trying to do. It was trying to compare apples to apples. The Corps disclosed the limitations of its models to predict habitat changes and environmental costs. It wasn't trying to predict these with absolute certainty. It was interested in the relative differences between each alternative. We're looking at environmental costs. The Corps had volume data.
Counsel, can I ask a question?
Yes.
Ms. Griffith indicated the renourishment was not occurring on the in alternative 5. The beach renourishment was not occurring on the east end, on the east side of the jetty that you're talking about putting in. Does the record reflect A, that that's true, they're not putting sand on the east end, and B, does it reflect anything about the impact of the renourishment on the east end over time?
That's a good question, Your Honor. And counsel is correct that the eastern end of the island will not be renourished under any of the alternatives, the far eastern end. That has been tried in the
undeveloped, like sort of the undeveloped.
Correct. Yes. So you have the islands developed, and then the last section of the island is undeveloped. And that end of the island has grown over time. As sand has been put on the beach, it's been transported to the east, extending that area. The problem with renourishing that end of the island is that it's quickly lost into the channel. And so it's correct that that section of the island will not be renourished. But what Audubon focuses on is the modeling results 1 year after the groin is constructed in one section of the beach. And Audubon claims that it will be dramatically eroding. The record supports that following that initial equilibrium period, that section of the beach will actually gain sand. It's undisputed that it's consistent with the leaky, low profile nature of the groin and the beach fillet that's put in behind that groin. So the whole purpose of Alternative 5 is to not only protect houses and infrastructure, it's also allow sand to be continued transported to that end of the island. If the analysis is wrong, or if conditions change, there are enforceable mandatory mitigation measures that are in place. So in other words, really what the Corps was trying to do was compare apples to apples here, and it did that in every turn of the analysis. I see my time's up.
I just want to make sure I understand, Mr. Ressler. You're saying in the sense that the jetty has almost a cure period, what you call equilibrium, where once it cures itself, then that east side of it should be abate the problem of the erosion that council mentioned. Is that
That's correct, Your Honor. Each alternative has an equilibrium period. That when you put a natural system out of equilibrium by either placing sand on the beach or putting a structure in place, the natural environment will try to respond to that. And so there is a period of time that it's trying to reach that equilibrium. And that's what the model shows. The model shows that that section of the beach east of the groin will initially erode, but in years 2 and 3 after the groin is in place, that section of the beach will actually equilibrate or gain sand.
All right, thank you. Ms. Griffith, you have time reserved. We hear from you.
Thank you, Your Honor. To start with a question from Judge Richardson, we're talking about sand here, and whether we're talking about it in cubic yards or acres, it's still the amount of sand that determines in both 2 and 3 dimensions what's underwater and what is exposed beach. And so if you have a situation where if you look at one section of the record, you're standing on the sand, and another section of the record, and you're a foot underwater, there's nothing for people to understand or compare there. And there's no reasonable basis for the Corps to make its permitting decision. And so creating, presenting the record like that and making a choice to use one set of numbers for environmental harms and another set of numbers for economic harms is an irrational decision. And the Corps provided no
Which way are you saying that that's wrong? There are two possible ways. One, that it shouldn't, that the use of acreage is a problem, that when we talk about habitat, you shouldn't use acreage? Or are you saying that, in fact, the best way to anticipate acreage is sand volume? Which is the problem you've got with that analysis?
I don't think there's one way or another that it has to be done. I think one way that would have been fairly straightforward to do it and provide the both fairness and transparency and the relative trends, which is all the Corps says their model can do anyway, is to say, you know, here are the environmental harms, here are the economic harms. We're showing you these to give a fair comparison, but we're concerned that they're understated. So that would have been one way to do it, but I don't think that's the only way. And to put this in context, the comparison of economic and environmental impacts here is just fundamentally on different footing. And I think it's not enough to say that the erosion would reach some sort of equilibrium or stabilize after a year, because this is a 30-year project. And that wasn't the reasoning for cutting short analysis. That's a post hoc rationale. What was the rationale was that we have these nourishment cycles every 2 to 5 years. But as council have agreed, that doesn't affect the relevant part of the island that we're worried about, and that the Fish and Wildlife Service said would essentially be destroyed if the terminal groin was built, and only if the terminal groin was built, not under the other consequences.
I'm sorry, can I ask a question then? So do you disagree that, I mean, I thought the record did show, I don't know, there's 74,000, there's a loss in year one after the groin is built, but that in years 2 and 3, that they will actually accrete or add sand. And so I guess I'm not, if that's true, what's it doesn't strike me that then you would need the beach renourishment on the east end, or at least that's a reasonable sort of conclusion to come to.
Well, I think that is what the record says, but again, we only have those 3 years to look at, so it's unclear, what that shows. And in other aspects, they did look at longer positions, so there's no reason it couldn't happen there. And I think the other thing is that it's not a question of whether you need beach renourishment on the east end or not. The harm is done. And I think that's one of the reasons that the proposal to fix it with additional mitigation would be unsuccessful. The harm is done there. And any harm beyond that we don't know about because it wasn't measured is going to accumulate in addition to that and only make the harms worse. And we have not conceded that these harms are modest. The question is, when they are measured, are they fairly capturing the harm and allowing it to be compared to the impacts there? And that didn't happen. And if the Corps had taken a hard look, this project could not have been permitted. Thank you.
Thank you. Thank you very much. Thank you, counsel, for your argument. We can't come down and greet you, but please know that our appreciation for your argument is nonetheless very heartfelt, and we thank you so much. And we wish you well, be safe, and stay well. Thank you, counsel. And with that, I'll ask the deputy clerk to adjourn the court.
This honorable court stands adjourned until this afternoon.